Welcome to the Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program, as we tell you, has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that will help you decide whether or not you actually need to contact a lawyer. Perhaps will help you to determine that you can handle some issues yourself. If you do decide to seek outside professional counsel, you'll be better prepared, and as a result, so will the professional you select. Either way, our goal, of course, is to have you save time, money, and achieve the best possible results. We want to, of course, welcome and thank from the Bazar and Associates Law Firm in East Providence, Attorney David Bazar, who continues to donate his time and energy, experience, and insights on the various topics that we tackle. So as we think about today's topic, we have spoken in the past a little bit about advanced care planning. Today we're going to cover that with a little more depth. We've reviewed the basic elements of what the durable power of attorney is, the living will, and such. So now the question is, with some specific examples, how can these help you tackle your issues? Everyone's situation is unique, so we can't go through each and every possible scenario, but a few that will hopefully offer some insights. Things about long-term care planning, Medicaid annuities, and veterans benefits, and on and on. So David, first, we know that you're a lawyer. We know that there is such a thing as an elder care attorney. What kinds of things do you need to know that are special and specific to this area of law?
So when people think of the term elder care law or elder care attorneys, they usually are thinking in terms of Medicaid planning and estate planning and estate settlement and veterans benefits and those types of things. So it is all of the things that you really sort of have to face as you age. And we will get into some detail as to the biggest issues about long-term care planning and making yourself either able to pay for long-term care, what we might call your stay-at-home plan or your age-in-place plan. But it involves a wide variety of things, as I said. So it's just an attorney who can help people focus on all of those issues that they face as they get older.
And I always wonder at what age you really need to start thinking about that. It could be someone who's 40, even thinking ahead with their children, their grandchildren that are coming or whatever. But who do you suppose actually starts to work on this, and who are you really targeting in terms of who will need care?
Right. So there's a couple of things that happen, and this is what I commonly see with estate planning. And as we go along, the first thing we deal with is who's going to need care as people age. And in the United States, as the population has aged, we found that there's a high percentage of the older population that eventually is going to need care. What happens is when people come in for estate planning, many times they start out at the earlier ages. I've just got married, I'm having children, I want to plan for who's going to help protect my children. Then they get older, they want to make sure they have money that gets to their children. And then as they age, they want to know, how can I protect the money I've earned so that it can get to my children? So this population that you see up on the screen is the aged population that's now concerned about protecting assets.
So quickly, people are going to be saying, what about that 60, 65, 75 and plus? But you're actually saying that it matters to think ahead of that. Not that you won't revisit it along the way.
Well, it comes up in two areas. It'll come up as you age, because as you age at some point in time, it's likely, and you can see from the slides that we have, that you're going to need help. But also, it's people who are either facing a disability or some other illness that is going to make it more likely than not that they'll shortly be in the need for some long-term care.
And as that slide indicates, many end up with Alzheimer's or something that is going to impair their judgment, and so planning for that is part of what you do. How do you do that, David?
Yeah, so the number of people facing Alzheimer's disease as the population ages is going to increase dramatically, and that is a point in time where you catch it early, you can start planning, but as the disease progresses, you go from being able to plan proactively to crisis planning. And so the idea is to get a plan in place as soon as you can so that you have the ability to proactively plan what you're going to do for your care as you age.
And of course, we're going to be talking about Medicaid element of it and spending down and whatever else happens, but this is not just for those who are already Medicaid eligible, but there are many things you have to think about when it comes to plan for how you're paying for these things.
Sure.
How does this work?
The planning involves trying to make yourself be in a position that when you do need long-term care, it can be paid for. And there are a number of different ways that it can be paid for. And so you want to make sure that given your situation, you've taken the best opportunity to pay for it, whether it's going to be paid for privately or paid for through long-term health cost insurance, as we talked about, or paid for through Medicaid planning and Medicaid. And the problem is the expense, as you can see, is extremely high. If you stay at home and you're going to bring in somebody to help care for you at the average of about $21 an hour, that adds up. If you need to go into assisted living, it's expensive, and of course the cost of nursing home is astronomical.
And so as you look at this slide that's up, we talk about I was going to ask what the ranges might be, and this is for some average, I guess, that they've managed to work with. But of course, these things will change based on what needs the person has, what the capabilities of the nursing home might be, and even what the amenities might be, because there's a wide degree of variance there.
If you can pay privately and you can have the pick of the place you want to be, it's probably more expensive, but you get the amenities you want. If you have to rely on Medicaid to pay, you have to find a facility that will accept the Medicaid payments, and with those payments come some limitations. So it's a give and take as to how you deal with these things going forward.
Let's just touch on the ethics of it for a moment. We're going to talk about the payment options, and obviously the first issues you're going to have address is going to be issues with paying with your own money, your own resources, net worth, savings, or whatever. And the goal, they say, is spending down so that you can qualify for Medicaid. Is that actually an ethical thing to do? Is it just a matter of how you package that so that you're not really trying to bilk the state, but you wanted to plan ahead? How do you deal with that, David?
People work their entire lives to save some money, maybe acquire a home, retirement assets, those types of things. So they can use that money to pay, and as we said, there are some advantages to being a private pay person going in. You can do some planning so that you at some point will qualify and protect some of your assets. And so, as the slide might say, it's a combination of doing all of those things. And protecting assets is not an unethical thing to do.
Good to know. And when it comes to planning ahead, most people talk about protecting or saving the home, but in planning, you're also talking about planning to protect their savings or their investments when you're doing this as well.
Yes, and so what you have to know is, as an eldercare attorney, as you say at the beginning, the eligibility requirements for when somebody would become eligible for Medicaid. If they don't have enough money to pay for their entire life expectancy and maintain assets, because you saw how expensive that would be. So knowing what the requirements are, you can plan. And there's a difference between proactive planning and crisis planning. And as we move along, we can get into some examples of proactive planning.
Before we do, when you address the issue of proactive planning, might that also include the very place, the very nursing home that someone might want to be in when they are thinking ahead, if they have that option, that is?
Of course. And one of the things I would do when I meet with people who are coming in is explore how they want to age at what's their plan for aging? Do they want to age at home? And is there a possibility and a way to do that? Do they want to know what their options are? And usually it's when you're in the crisis situation where that's shortly going to happen that you want to start looking at a facility, and you need to know whether the facility would accept Medicaid payments, or is it just private pay? Where is it located? How close is it for family to be able to visit? Does it have the amenities, as you say, the things that you particularly need for your skilled care?
Could you also answer this, David? If someone is planning on doing a private pay because they've made some provisions and you've helped, or someone like you has helped them plan for it, when they've spent down, could that nursing home then ethically move them out? Could they be rejected and have to go elsewhere because now they're Medicaid eligible?
So you're asking, can you be evicted from a nursing home? And
Period,
there is
yes.
a process. It's a difficult process for the nursing home, but eventually it's something that can happen. And that's why we tried to plan so that that wouldn't happen. And the plan that we put in place is, if you're at a nursing home you like and you know that nursing home would eventually accept Medicaid payments, then you're not going to be evicted because you're no longer able to privately pay.
Okay, so you of course want to avoid losing everything that you've ever saved for, and you want to make things as comfortable as you possibly can. We have an example of, well, in terms of what you want to avoid, leaving your home unprotected. Does that mean so that you're going to lose the home, or it's just not planned for in place?
What you want to do is make sure that if you're going to end up in a nursing home, that you don't run out of money, so you don't deplete all your assets, so you don't put your home at risk. And the biggest thing, and it's on that slide, is the health and welfare and well-being of either the stay-at-home or community spouse or the family who are giving the care, because it can be a tremendous drain on the family to care for somebody who should otherwise be in a nursing home.
So would that community spouse, would that also perhaps include some care or respite for her or him if they're having to take care of a house plus whatever trips back and forth to the nursing home?
Well, the care and
whatever.
respite would be getting the spouse that needs the care into the correct facility, so they no longer have to provide it. Got
it. So let's talk a little bit about Mary. So we have an example of Mary, who was 78, lost her husband to cancer. The family wants to make sure that she'd be taken care of. She has 2 children in different states, and they're a little bit worried. She owns a home and $225,000 in checking savings and CD. She had a long-term care policy, it said, that she'd been paying for 20 years. Is that typical?
Yeah.
Okay. And she would
that means she's paying a pretty reasonable premium for it.
Because she did it early.
Right.
Got it. So she provided a benefit of $75 daily, which seems reasonable. So now her aging in place plan looks like what? She gets to stay?
Well,
in that
so here we are with
policy?
Mary. So Mary, if you notice the math that you just did, if I'm following along, was 58 when she started buying the long-term care policy. Did you say she'd been paying for 20 years? Since she's 78 now. She's lost her husband, so there's no community spouse or stay-at-home spouse that we need to plan for. And she is not, at this point in time, likely or thinking about that she's going to be in a nursing home soon. That's good, because that gives us time to plan. And the proactive planning that you can do is very different from the crisis planning. So what are some of the things that Mary has to worry about? She's got $225,000 in liquid assets and a house. Does it tell us how much the house is worth?
I don't believe so.
Okay. Well, let's make believe that the house is paid for and it's worth $400,000. And that's important because there's a limit on how much equity you can have in the house. So
does that vary state to state? How much equity you could have in a house?
It can.
Okay.
It can, but in Rhode Island it's about $500,000 and some odd, as I recall. So what Mary can do is make some planning to protect the house and her money. And when someone comes in to me in Mary's situation, it's not just about planning to protect all of her assets against Medicaid, because Mary might not even be thinking about that. But what I'll typically do is I'll say, Mary, sorry for the loss of your husband, but I'm glad you're taking the time to think about what your next step is and how I can help you with that. What are your goals? And so I need to know what Mary's goals are first, so I can help her achieve those goals. Is her goal to spend all her money and travel around the world? Well, that's a very different plan than it might be for, I live modestly, I want to protect my assets, and I want to pass those on to my children. Because if that's her goal, what we can do is we can do some planning with the house, where she might retain a life estate in the house, for example, or put the house and some money into what I call a family protection trust. Other people might call a Medicaid asset protection trust, but it's really a trust that's an irrevocable trust, and it's designed to get the money out of Mary's hands. She no longer has any control over it. And therefore wouldn't be countable against her for Medicaid purposes. But, and here's the key, for it to work in most states, it has to be out of her hands for more than 5 years, because that's what you commonly hear people come in, what's this 5-year look-back period? Well, that's what the 5-year look-back period is. If you gave away assets and putting the assets into an irrevocable trust,
is that considered?
It's giving it away.
Giving it
because
away.
Mary no longer has, I don't know if I said irrevocable at the beginning of that, but it's an irrevocable trust. And she no longer has control over the assets, and the assets are no longer hers. So since that's the case, Medicaid doesn't count that. But if it's a gift that she gave away in 5 years, they get it back, because you have a penalty for giving it away.
Okay, so the thought is she might want to keep some liquid assets, right, and put the home in a trust. The thought is she could keep $50,000 in a revocable trust so that she could play with it. She wants to travel, she needs to put a new roof on.
This is part of the whole planning with Mary, is how much money are you comfortable giving away, and how much money do you feel you need to live your life? So if Mary wants to take, you use the $50,000 example, and put it into a revocable trust, that's her money. That money counts as a Medicaid asset in terms of whether or not she would get that money, use that money to pay for a nursing home and not qualify for Medicaid. But as you said, she can use it to travel, she can use it for home repairs, she can use it for anything she wants to use it for, because it's her money.
And what happens if somewhere along the line she wants to change her mind? She thought she might want to stay in the home, but maybe the situation changed through no fault of her own, or maybe something else changed. If it's irrevocable, she can no longer tap that fund, right? It's done. She can
no longer tap the fund, and her house is potentially in that. But there is language in the trust about Mary's right to live in the home. So she always retains the right to live in the home. And the trustees could, if Mary doesn't want to live in that particular home any longer, sell the home and buy something else if she wanted to. But if she just sold it, the funds itself would stay in the trust.
Interesting. And an element that I think it makes sense we should discuss now is the idea of if her husband were a vet versus if she actually had served.
Yeah.
How does that work?
So
David?
Those are other benefits that are available in addition to potentially using Medicaid to pay for assets. If she were a vet and a disabled vet, there's money that she might be qualified for on a monthly basis. If her husband was a vet, she could also potentially qualify if he served in a wartime situation and she were disabled. She might have the right to receive some benefits too.
So as I looked at that example, David, in the case if her husband were a vet, she receives a certain amount dependent upon her health situation. If she were the vet, would the amount then not be determined by her health situation, just what she's entitled to as a flat certain fee that's
calculated? No, there's
calculated?
still a disability component to that.
Okay, it's about the
but there's an
disability.
additional benefit, which is also based on assets and income similar to Medicaid, which is what sometimes is referred to as an aid and attendant benefit. It's help for someone to stay home and have care, or if the husband were the vet, or she were the vet actually, and she qualified for it, she could go to the veterans home and have her care taken care of there.
When someone does qualify for Medicaid, it's not just about putting them in a facility. It could be for them to be staying at home, as I understand, and aging in place, as you say.
Right.
Does that also cover services that might mean having a nurse come in to do blood samples or whatever else?
Rhode Island has a waiver program for Medicaid. And what they mean by the waiver program, it's if you were otherwise qualified to be in a nursing home, you might qualify to get care at home, CNA care, other nursing care at home, so that you can stay home. It's sort of a win-win in the sense the amount that the state pays is usually much less than they would pay for someone to be in a nursing home. And you keep your loved one at home, which is oftentimes the goal. And if you get some aid and help at home through this program, you may be able to do that with less stress on the family members.
If it's provided through Medicaid, they control in the nursing home what your spending allowance is for your snacks or whatever else. I understand that there's a difference in the amount if you were to be at home, Medicaid covered for services, but perhaps they would be looking at a different amount of money that you would have as spendable cash. Is that based on you needing to buy your own food or something?
Well, it's a different program, so depending on what your needs are and what the state is paying for, there might be some other money available to you from your income, et cetera, to be able to pay for certain things.
So still, would you generally advise that someone take care of their own long-term care for a facility, that's something they should plan for rather than wait to see how things started to play out, if children were leaving, children were staying, taking care of them? Sometimes parents we'll hear parents say, my children will stay and take care of me. I don't have to worry about that.
Right, we hear that a lot. I'm not going anywhere. If my children don't want to take care of me, I'll spend everything I have to take care of myself. And, you know, it's their money. They can do what they want. We can suggest reasonable options, but in the end, it's the person that you represent's choice as to what options they want to choose and how they want to do it.
As a lawyer with a conscience, would you be likely to say, well, it may play out that way, but let's plan in case it does not?
I think as a lawyer, we usually always are planning for what's going to happen and what might happen, because you never know which one's going to be, and you can't rely on this has definitely happened, because this has definitely happened doesn't always happen.
And if you're helping someone with their long-term planning for a facility, is it actuarial studies so that you can help them determine at what point or in their age that it's no longer reasonable for them to start to invest in a long-term care plan? In other words, it must cost less at 40 if you started to do this than if you were starting to think of it at 70.
So you're talking about long-term care insurance.
Insurance.
And they absolutely has to be a much lower cost to buy it at a younger age, because the actuarial experience, as you say, is that you won't need the benefits until you're older. Not always true, but potentially true. And so based on statistics that they use, the older you are when you buy it, the more it's going to cost. And there is going to come a time where at your age, the expense of what you're buying isn't worth the benefit that you're going to receive. So it's not something that I study or can tell you that, yep, at age 72, don't buy it anymore, or I'm just making that age up.
Sure.
But what I would tell you is contact somebody who sells the best product that you can buy and find out what the cost is and make a determination as to whether or not, in your situation, given your income and your assets, if it's worth the investment.
So would this also build the case, as you had started to earlier, about it's worthwhile for that 40-year-old who is working with you or working with a lawyer for you to have that conversation? Look at it now, because those numbers will look much better than when you start to do this at 30 years down the road.
So when we meet with a couple or an individual for a trust and estate plan, no matter what age they are, we always ask them their goals first. and then we raise the other goals. And certainly a young couple is probably not going to think about worrying about long-term care insurance, but it's raised just so they know it's out there as an option, and based on what their income and assets are, is it something that might be worth looking into or not? Many times they're not interested until they're a little bit older, but it's to their benefit just to know what the options are.
So you may suggest that they do this. Is this one of the occasions where, I think we've talked about it in similar situations with perhaps a divorce situation or some other insurance settlement, that you might actually bring in an accountant at the same time to look at some of the numbers to see what works out best? Would that ever apply to the 40-year-old who's thinking, I might want to put the money away for my child's college versus for my
Of course. And it might not be an accountant, it might be a financial planner, it might be a combination of a financial planner, an accountant, and an insurance agent. So a lot of times people are more concerned about, and rightfully so, when they have young children, having enough life insurance in place to protect their children if something should happen to them. So there's probably 3 or 4 professionals that really, in any plan, may need to be consulted.
Okay, and while we're talking about Medicaid, I think most of the time we think about the Medicaid for the elderly. Address, if you will, the idea of Medicaid not just being for the elderly, but for some children and adults who have other needs.
Yeah, if you have special needs, blind, disabled for one reason or another, you will qualify for certain Medicaid benefits as well. And one of the things we often do is, when we're dealing with that situation, and we usually maybe have the parents of a child, we need to talk to them about their planning. And the goal is, if the child is going to qualify for Medicaid because of their disability or whatever it is that causes them to qualify, you don't want to put them in a situation where they will become disqualified because they've either inherited money, or you've gifted them money, or you've made their assets such that they are no longer in the level where they qualify. So we talk to them oftentimes about special needs trusts. And this is also something with spouses, where one of the spouses is now qualified for Medicaid, but the other spouse doesn't want to leave nothing to that spouse. You know, it's the person I've been with my whole life. I don't want to just ignore her in my will or whatever. So we often create a special needs trust, but that has to be done testamentary or in the will, so that it doesn't disqualify the spouse and, as we were talking about, the child from their benefits.
You said in the will as opposed to in the estate?
In a will for a community spouse. That's part of an estate plan.
That's part of an estate plan. Okay, good to know. We understand that in each state, Social Security, SSI, has different income limits. Certainly someone could very easily look online to see what that is. That's a start. I've heard that some people figure that once they look at and find out that number, that's all that they need to do. No reason to do any other planning. From what you're saying here, there certainly is a difference in terms of how much nursing homes could cost and how much you're allowed to have on for your own before you qualify.
Right.
Looks to me like it's certainly not something that someone could easily just look at online.
You can go and look up the regs, but if you can figure out and understand everything you need to know from the regs, call me, because I need more people to help me with that kind of work.
I understand that you can ask the questions that they don't know to ask, which certainly you've raised here. We hope that this has been helpful to you in planning for long-term care. We hope that you will continue to stay tuned to The Law Matters, because it matters to you.
All right.